privilege to be able to welcome you to the 2019 CSJ Center for Reconciliation and Justice Symposium. On behalf of Sister Judith Royer and myself, Sister Mary Ann Hipper, and Stephanie, I'm very happy to welcome you to our first session. This session, Homelessness, It Could Happen to You, I think is a really important issue for those living on the edge because it deals with something we don't often talk about, and that is the relationship of the law and renters, employment, and the law, and how that can impact people and put them on the street in no time. So welcome again, and thank you for participating in this session, and we welcome you to further sessions. Again, thank you. I would like to introduce our two speakers today, Nnogo Obiamiwe, Principal for the Law Offices of Nnogo Obiamiwe, APC, and Adjunct Professor here at LMU. She has an office right over here in Hilton. And we had a chance meeting at an event, an opening of the Mass of the Holy Spirit, where we introduced ourselves and talked a little bit about what we were about. And she mentioned to me that she happened to work with this whole issue around tenant and landlord and employment law. And what a wonderful thing to be able to have as one of those topics so related to those who are homeless. She has brought with her Emmanuel Okoji, who also works with the same law firm and is a law clerk. And between the two of them, they'll give us a wonderful presentation on, I think, a very pertinent topic and one which we may not be as familiar with. So I don't want to take any more time. Please begin.
Thank you very much, Sister Mary, for the very generous introduction. As Sister Mary said, my name is Nnogo Obiamiwe, and just so you can be familiar with me, I'm sure you can hear an accent. I do have an accent. Everybody does have an accent, but mine is not an American accent because I'm actually Nigerian. So I was born and raised in Nigeria. I moved to Los Angeles after attending college in Budapest, Hungary, where I got my bachelor's and my master's degree, and I came here. I taught school for about 10 years. I taught grade school, and then I decided I wanted to follow in the footsteps of my father, who was a lawyer, which was something I never thought that I would do. Two things I thought I would never do: a teacher and a lawyer, and now I'm both. My mom is a teacher, and my dad, who passed on many years ago, was a lawyer. So I just fell into this area of housing discrimination and employment law because I was involved in it with a friend. So when I was in law school, I had a friend approach me who was facing an eviction, and that's how I fell into this, because I always thought that I was going to get into immigration law. So here I am, and I'm so honored to be here. I have a tendency to shed a tear or two because I get really passionate about what I do, and it's not unusual to find me tearing up during a trial as I'm giving my opening statement or my closing argument. So please bear with me. This whole situation of homelessness in America it's really sad, and it's a huge crisis. It has become a really big crisis, which really has not a lot to do. In fact, I think it's very little to do with, as many people think, the mental state. Well, perhaps somebody is an alcoholic or has mental problems or is sick. Those kinds of people who become homeless make up just a small percentage of homeless people in America. And by the way, California has the most or the highest percentage of homelessness in the United States of America. And within California, Los Angeles County has the highest rate of homelessness. So it's important for us to know that in California, the statistics have shown that the reason why a lot of people are homeless is not necessarily because of what I just discussed, like the mental states of people or, their alcoholism or, things of that nature. It has to do with the cost of housing. The cost of housing has skyrocketed in California, especially. So while a lack of affordability has affected a lot of people in the United States, the focus and the problem is really, really bad here. I believe it's about 150,000 people who are homeless in California. That's the size of Pasadena. And can you imagine that amount of people just living in cardboard boxes and under bridges and freeways? That's a lot of people who are affected by this crisis. And it's not only people think, it's perhaps only Los Angeles County that's affected by the homelessness in California, or urban places. No, it's also rural places. So out of the 58 counties, all 58 counties in California have the problem with homelessness. Okay? So it impacts all 58 counties in California, whether you're rural or urban, northern, southern, inland or coastal, whether you're by the beach or closer to the mountains, it doesn't matter. We have a lot of homeless people everywhere. It impacts individuals and families of every background. I have a sister, an older sister, she's been a professor at Santa Monica College for over 20 years. She goes through the stints where she has to move in with me for periods of time because she can't afford the rent. She fell into a situation where she had to leave her apartment, and so she's in this situation now. She just moved out in December. She found a place. I'm not sure when next she's going to move in. This is somebody who's educated, has a job, but still cannot afford to live anywhere around here. Okay? So I'll give you a few statistics, just so you know. 24% of the nation's total homeless population lives in California. This is the nation's highest rate. Los Angeles County, as I said, has the most within the state. 55,000 people are homeless in LA County. California's homeless population rose by 14%, almost 14%, between 2016 and 2017. So on any given night in California, it's actually approximately 135,000 people who are homeless. Those people are without a home. California does not have enough affordable rental homes. Supposedly, 22% of the homes in California, the rental homes, are for low-income citizens. And I don't even agree with that number. I think it's a lot less. Okay? So there is a close connection between housing costs and homelessness. I'm not going to even get into the San Francisco. San Francisco has it pretty badly as well. But now, thankfully, we have some mayors, which includes, I think, the Los Angeles mayor, the San Francisco mayor, and perhaps Oakland. They're trying to petition the federal government to invest more in affordable housing. So let's hope something comes out of that. Now here, the next thing I really wanted to talk about is how I tie in employment and housing, landlord-tenant problems with homelessness. We all know that we're all, maybe not all of us, but a lot of us are a paycheck away from being homeless. You lose your job. You can't find a job for whatever reason. Some of us are older. Some of us face, you don't get a job because, you look a certain way, you speak a certain way, you're disabled, people perceive you to be something else, and based on that perception, they refuse to give you or rent you a place. So we have that loss of employment as a major problem. We have lack of affordable housing, correlating very, very closely with high housing costs, and it's the fact that people just cannot afford it. Californians spend over 50%. The average Californian today is spending over 50% of their income for those people who have jobs on their housing. That leaves you with not a lot. to spend on other things. So we know that employment is a problem that's very highly linked to being homeless. The other thing that's highly linked to being homeless is when people don't know their rights. And that's why I'm here today, is to give you information, tell you what your rights are, what your obligations are as a tenant and as an employee, for those of us who are employees, so that you can avoid the scenario or the scenarios of being kicked out of your apartment or where you live and losing your job. You know, you need to know your rights. What things can you do to avoid losing your job? What things can you do to avoid losing your home? And if those things happen to you, do you have any legal recourse? Many people have legal. A lot of people have a reason to. I'm not saying file a lawsuit against your employer and your landlord every time you lose either your job or your housing, but a lot of times there's a reason why. There's a basis for you to bring a lawsuit against your employer or your housing provider. And my job is to protect the underdog. That's my job. I do not represent landlords ever. I get calls from them, and with all due respect, there are lots of people who do it, but I don't do that. My main focus is tenants and employees. That's all I do, 100% of my practice. So, what I will do today is I'm going to try to contain it. There's a lot of information that I need to, I feel like I would love to give you all that information so you can be armed, okay? But I don't want to overwhelm you, okay? It can be overwhelming. And what I say to my clients when they come to me and I take their case is like, I'm taking over, okay? I'm taking over, just chill, okay? It's not easy. So if you would like to connect with me afterward, or you want me to give you information on resources that I've discussed during the seminar today, please put your email on the yellow pad that's on the table to my right, and I will, and you're welcome to take my card as well, and I will send resources to you, because there are resources, okay? There are resources when you have an eviction action filed against you. They have Betsedic, for instance, that will, Legal Aid Foundation, that will handle your case most of the time pro bono, which is free of charge. Sometimes they'll go after the landlord if they win, and the landlord will pay for their attorney's fees. But many of these resourceful facilities or companies or whatever you may call them handle cases for free. I too handle, when I can, I do handle some eviction actions for some of my clients, especially when I know that they have a lawsuit going on, or they will have a lawsuit against their landlord. So what I would do is I'll handle the eviction, okay? Having said that, I'm going to try to be systematic with my discussion today. But sometimes I tend to be passionate, as I said, and that passion can seep in and make me look like I'm erratic. Forgive me, okay? Forgive me. I am very passionate about what I do. And so you'll forgive me if I sometimes digress. I remember something that happened. It might be a case that I've just recently handled, and I want to get that information to you before my 52-year-old brain forgets, so just bear with me. The first thing I wanted to talk about is like the landlord disclosures in California. There are some disclosures that a landlord has to give you. You need to be aware of those disclosures, okay? The first is, and this is a very common issue that many people do not know about. Sometimes you have your gas or electricity being used by the landlord, and you have no idea. So they'll have a socket somewhere outside your apartment, and that socket is connected to your apartment. You don't know, but it is, okay? A landlord has an obligation to inform a tenant if that's the case. if you're going to be sharing your electricity and therefore paying for somebody else's electricity, your landlord has to let you know. I have an ongoing case now where the landlord does exactly that. Socket is next to her unit, and she sees a spike in her electricity bill every so often when construction is going on. The next month, boom, it's up by $30, her bill. Okay, so that's the first thing. The next thing is information about toxic mold. If the landlord knows that there's mold in the unit, it's usually toxic mold, because we know that you have, I think there's mold everywhere, okay? But when the landlord knows that this is, it's more than just a little bit of mold, the landlord has an obligation to let you know about that mold. Okay, especially because mold can be extremely dangerous. I have a mold case now. We actually have 2 mold cases right now. Mold can be extremely dangerous. It can be fatal. People don't know this. Yes. And those cases can be very high profile, can settle for a lot of money. You can be a little bit of a happy camper later on when you sue your landlord, and the landlord does what he should do, which is put some money in your pocket to compensate you. Nothing can give you back your health, though, but, as I tell my clients, at least I can put you in a better place to be able to handle whatever, God forbid, health issues that you may have gotten as a result or consequence of the mold. Okay, so that's the mold exposure, must be disclosed. The other thing is the pest control service. That's very important. There's something I call the Big Four that I see a lot of these days. The Big Four pests that we see in Southern California: roaches, rodents, bed bugs, and the last one is mold. Well, yeah, mold. It's not a pest, but it's a problem. The landlord has to let you know what pest control company he or she is using, what pesticides and the active ingredients that are being used in the pesticide, because those pesticides are toxic, okay? And by the way, you have a right to ask the landlord not to use pesticides if your doctor has said that a pesticide will affect your health. We had a case a couple years ago where I had a 90-year-old client, 90 years old, and he had a huge bed bug problem. Like, there was bed bugs all over. He complained about it to the management company, and they told him that he brought the bed bugs in. I mean, this guy has lived in the same apartment for 10 years. So all of a sudden, where did he bring the bed bug? He hardly goes anywhere. He's always in his home, and his daughter picks him up, maybe doctor's visits. That's about it. Didn't buy any new beds, nothing. It was just there was an infestation in the complex. So he reported that after they got through over that hurdle of, you brought the bed bugs, and he was like, no, I didn't. The next step was, well, you have to eradicate it, which, by the way, the minute you tell your landlord about an infestation, especially bed bug, now the civil code, I think it's civil code 1950.6 something, or 650, I don't know, says that within 2 days of a tenant telling a landlord that there's a bed bug infestation, the landlord has to actually not eradicate, but spray. The landlord has to take care of it. Exterminate is the word I'm looking for. Within 48 hours of a tenant telling a landlord about the bed bug infestation, the landlord must have a licensed company exterminate. So in this case, my client was essentially, if they had sprayed, if they had used chemicals, it would have killed him. Like, that was it. So he said, he got a note from the doctor saying, this is not going to work. There's an alternative way of doing this. It's called the HEAT system, HEAT, H-E-A-T. They can treat the place using heat. It's just as effective as chemicals, if not better. They weren't having any of it. And when I say they, I mean the landlord. The landlord said, no, we're not doing that. And if you want to do it, we're going to charge you $3,500. At that point, my client, the 90-year-old, the daughter, called my office, and I was incensed. I was just like, this guy's 90. Literally, seriously, if he lives like another 10 years, wow, you can't wait 10 years? You can't just pray and wait 10 years for him to, pass on? Because, come on, he's 90. Can he live his life? I got so angry. We handled this. We took it to federal court. That was a federal court case. Immediately, we did a petition for an injunction. It's called an injunction, which means a stop order, because I forgot to tell you what happened. So when they charged him the $3,500, this guy, he didn't have the money to pay. Low income and didn't have money. He's a veteran, by the way. They went ahead and they did the heat treatment and then gave him the bill for $3,500 and gave him 3 days to pay the bill. I know. I wasn't laughing that day. I was just like, I had smoke coming out of my ears, like everywhere. I was just like, 3 days for him. His daughter was about to go on vacation with her family, a planned vacation that they had planned for, I don't know, a year or so. They put everything on hold, and he had to move into the daughter's house. Again, he's 90. The daughter has a duplex up and down, so the bedrooms are upstairs. He couldn't sleep upstairs. Like, he had to sleep on the couch in his daughter's room. So the federal court immediately faxed their ruling. It was awesome. Like, the next morning I get to work, there's a fax machine. And those days that was 2 years ago, the fax machine. The federal court had already faxed the ruling, like, stop with that eviction. It was lovely. That day I was like, thank you, Jesus, Yes. So immediately they had to stop all of that, right? So we're able to get an injunction, which is a stop order, as I like to tell my students. And I couldn't wait till I skipped to court like 3 days later to file that lawsuit. I only got an injunction. You need to put money in his pocket, because he went through so much. Having to stay on the couch, having to be moved to his daughter's place, just being worried, scared. He kept on saying to the daughter, am I going to be homeless? Can you imagine? Am I going to be homeless? Because he's such an independent guy. He doesn't like anybody taking care of him. When I would go visit him, he would bring out the spread, like all kinds of cookies and this and that, and do you want tea? And he's just the cutest old man that you can find. But anyway, we filed that lawsuit. And you don't know the case name, but guess how much they had to pay? $85,000. Hello, I told you to pay $3,500. Now you're having to pay $85,000 to compensate my client. Wow. That was how much it cost them. They could have done things the right way. We gave them many opportunities. Just take off, before we even filed the lawsuit, we said the injunction, we gave them an opportunity. Withdraw the eviction action, withdraw the 3-day notice. They weren't having any of it. But anyway, I tell you that for a reason. Sometimes many of us have certain disabilities that require a landlord to accommodate you in a way that makes it possible for you to live, if not exactly, but at least, close enough to somebody who doesn't have the disability. That's what we call reasonable accommodation. So the landlord has to reasonably accommodate tenants, and it has to be reasonable. $3,500 was reasonable, in our opinion. This is a huge apartment complex. They had a lot of money, okay? $3,500 wasn't a lot, and they ended up paying $85,000, like right away. Okay, they paid the money. So that's that with the disclosures. The next is the California security deposit laws. You need to know that as well. Landlords cannot charge more than 2 months' rent for security deposit. Okay? And it must be returned within 21 days of you moving out. So if a tenant moves out, 21 calendar days, the landlord has to give the tenant, whatever. If the tenant is getting whatever it is the tenant is getting, it has to be within 21 days, along with an itemization of the deductions that are being taken. California does not allow you as a landlord to take money for regular wear and tear. So if you lived in the apartment for 10 years, why is he charging you to paint the wall? right? The walls get dirty. I mean, it's reasonable that walls would get dirty. It's reasonable wear and tear. He shouldn't have that money taken out. But in any case, you get it. The landlord has to give you in writing, explain how much he's paying who, and give you the total amount that you're going to be getting, which a lot of times will be in the negative. Okay? And this is all in the California Civil Code. Again, I can give you all the information. If you give me your email, you need the code sections of the law, whatever. I can wait here after the discussion and give you all that information, or you can leave your information and I'll call you and send it to you. Now, what happens if your landlord has not given you your security deposit? What do you do? Yes. She said, file a small claims. And I said, yes, you file a small claims. Because here's what happens. If the small claims judge finds that the landlord is acting in bad faith, you're going to get 3 times your security deposit. So it's worth it. So if the court says, the judge, well, why did you charge this tenant for painting a wall when the tenant has been there for 10 years? That's bad faith. Most likely the court will give you 3 times your security deposit. Yes. So sometimes it's worth doing that. And if they don't do it by the deadline also, that's also another reason to maybe not just, I mean, if the amount is a large amount, like you give a large security deposit, he took out a lot, and then he was late on top of it, you can add that as part of the penalty. Okay? So that makes it worth it. Here's what I always tell my clients. In fact, just write a letter once you move out. Once you move out, write a letter. If you want to wait until the 22nd day, that's fine. Write a letter on the 22nd day. The reason why I say write a letter when you move out, or at least give them your forwarding address so that they know where to send your money, or the accounting, because I get this all the time. The landlord will say, well, he or she didn't give me a forwarding address, which a lot of times is not even true. But if you have a letter that you send by certified mail, then the burden will be on the landlord to prove that he didn't receive the letter. Okay? So you want to do that. Write the letter, certify it. I'm not trying to trap landlords, okay? People think that I'm just this bad person who's trying to trap landlords. Sometimes they call me and I give them advice, and I tell them, no, I don't think you should evict this person. I said, the case might land in my office. I do things like that. I give them good advice. However, if the landlord is just a horrible landlord, perhaps sometimes you wait until the 22nd day before you send the letter so that he can fall into the trap, right? Fall into the trap of not giving you your money and probably taking most of the money, and then you can file your small claims. Do you have anything to add, Mr. Koji? He is a king of the eviction actions. Like he helps a lot with the paperwork, because I get swamped and I just call him, and he gets really passionate too. He goes to their houses and Yeah,
the key to winning any eviction case is documentation. You have to document everything. If it's by text, email, writing a letter, that's the key. We've won an eviction case by text message. And the judge was like, do you have proof? Yeah, I have it. So document everything. It's easy. Because the landlord did document everything. If somebody wants you out, they're going to get you out. So you have to be smart, one step ahead.
Thank you. So again, maybe you don't know, but it's $10,000 is a max that you can get. So sometimes, perhaps your security deposit, I don't know, some people might have a higher security deposit. You have to think about all of that. Are you going to limit it to the $10,000 cap on small claims in California, especially if the judge has to triple it? You have to think about that. So if your security deposit is $4,000 and the judge wants to triple it, the judge will just give you the $10,000. The judge is not going to give you $12,000. Yeah, so you have to think about that. Another important thing is, like Emmanuel said, have documentation, okay? Take photographs of how you left the place. I have seen things that are unbelievable. Like my client will have a photograph, everything is clean, and then when the lawsuit is filed and we're doing what we call discovery, we're trying to discover what happened in the case, you get a picture of the bathtub and you're like, what? You look at the bathtub picture that your client gave you and the bathtub picture that came from the landlord. This is not the same place, is it? They doctor things, they'll set you up. Okay, so take a videotape if you can, record it, have lots of photographs. You can't have too many photographs. Document, document, document. Have a book where you write things. Here's what happened today. In fact, talk about your feelings. Here's how I felt today. It was awful. I threw up. I couldn't sleep. Have a book. Here's my landlord-tenant book. And have a book for your employment case too. We're going to talk about that too. All right? So you're leaving, assuming the landlord has been able to evict you. And before that, always ask for a final inspection as well. Ask for the landlord to allow you to inspect the place with the landlord, because cases have been won based on that. The landlord will take you to inspect the place, and the landlord will make comments such as, oh, you left this place really nice, wow, it's all cleaned up. And then when you get your security deposit, cleaning fee, $300, carpet, $1,000. Well, but you told me that I left the place in tip-top condition. What happened? Cases have been won based on that. So go for your final inspection, request a final inspection, you're entitled to a final inspection, and you have every right to record it. Okay? Let's move on to late fees and other rent-related issues. Late and bounce check fees is $25 for the first time you bounce a check. I don't care what your landlord says, $75. No, it's $25 by law. They can't charge more. $25 for your first bounce check, and then every other bounce check would be $35. The other thing that kind of is related to the checks is some landlords are asking for cash or money orders. The only time a landlord can do that is if you've bounced a check once before. So if you haven't bounced a check once before, the landlord cannot ask you, oh, give me only cash, okay? You need to be aware of that. So we've talked about the late and bounced check fees. What about when the landlord wants to increase the rent? Does anybody know the law on rental increases in California? Now, that depends on whether it's rent controlled or not, and we're going to talk about the rent controlled housing, which unfortunately is diminishing as we speak. But I know there was a prop on rent control. I'm not quite sure what happened to it, but I'm just hoping rent control doesn't just dissolve into oblivion, because that's how a lot of people can afford to live, is because of rent control. So with regards to increasing your rent, there's a rule. If the landlord is going to increase your rent by 10% or less, the landlord has to give you 30 days written notice. It must be in writing, okay? If it's going to be an increase that's more than 10%, the landlord has to give you 60 days written notice. And that's the law. So if the landlord serves you with a rent increase, where today is January 29, say on February 10th, the landlord gives you a rent increase notice effective March 1st, you can just ignore that and then call me up, okay? If you get a 3-day notice for not paying the higher amount, the landlord has to give you the full 30 days, and it's your right to just ignore it. If you want to be nice, you can call the landlord and say, this is improper, and when you give me the proper notice, then I will respond accordingly, but you don't have to do that, okay? They need to know their laws. They're just testing the waters. They know what's up. Most of them do know, okay? So how much time do you have to pay your rent? Assuming you don't pay your rent, the landlord must give you 3 days to pay your rent. The landlord must give you 3 days to pay your rent. So people ask me, well, isn't it just automatic that I have 3 days to pay my rent? No, it is not automatic that you have 3 days to pay. Like, if the rent is due on the 1st of the month, then you should pay your rent on the 1st of the month. There is no law that says, well, you can wait until the 3rd to pay your rent. What people get confused about is that if you don't pay your rent, the landlord must give you a 3-day notice to pay rent or quit. Okay? So you have 3 days to pay that rent, and then if you don't pay on the 3rd day, the landlord can file the eviction action. Now, here's another nice thing. Within that 3 days, assuming your rent is $1,500, and within the 3 days, you give your landlord, you say, oh, I just got $500, I'll give you the $1,000 next week, and you give the landlord the $500, now you have $1,000 left. If the landlord takes the $500, the landlord cannot proceed with the eviction. He or she has to file a new, or serve you with a new 3-day notice. That 3-day notice no longer works. So he took the $500, now he has to serve you with a 3-day notice to pay the $1,000. Okay, so bear that in mind, because some of the greedy landlords, they want to have their cake and eat it, and they'll take, okay, sure, I'll take the $500, but if you don't pay the rest in 2 days, I'm going to proceed with the eviction. You can just chuckle and say, okay, because at the eviction action, the court is going to say, get out of here, case dismissed. Okay, you accepted the partial rent. As long as you have documentation to show, and you didn't slip $500 in his hand, because, right, he can say, no, you never paid me. You're like, yes, I did. Here is the text that I said. And you were like, yeah, acknowledge receipt of the $500, right? So you have to have documentation. Then we move on to, we're still talking about rent increases and retaliation. I see that a lot, a huge correlation between when the landlord increases a tenant's rent and retaliation. Sometimes it's because the tenant has complained about stuff like, if asked for repairs, can you please fix the plumbing? My toilet keeps overflowing. Landlord has had to, call the plumber out. Landlord gets pretty upset, increases your rent. California says, no, you can't do that. You may not use rent increase in retaliation against a tenant for exercising his or her legal right. There are penalties which can be very, very steep when landlords do that. For example, I see the broken heaters a lot. Like, people are living without heaters. Like, people with children have no heater, no working heater, or no heater at all in their unit. That in California is a per se violation. Okay, remember we talked in the beginning, I may have mentioned that, well, maybe not, but you as a tenant, you have your rights and obligations. The landlord has his or her rights and obligations as well. What are your obligations? Pay your rent on time, be a good tenant, don't make noise, don't trash the place, don't have loud parties, right? Those are your obligations. What are your rights? Be able to live in a peaceful place that's free from people harassing you, right? The landlord to provide a place that's safe, have lighting by the carport so you don't fall down, fix things. If the railing is broken, fix the railing, fix whatever needs to be fixed inside your unit. Those are your rights as a tenant that should come from the landlord. And so the rights and obligations kind of like cross. So what are your obligations will be the landlord's right? Your obligation is to pay rent. He has a right to collect rent. Your obligation is to be quiet as a tenant. He has a right for you to be a quiet tenant. So it's like, kind of switches. But what I see a lot is the retaliation. You've asked for your heater to be fixed. Landlord is pretty upset because he's spending money fixing that heater. And then he retaliates. That's why I said have your little notebook, my landlord-tenant notebook, write everything there. Something like a heater, that's, in my opinion, that's a major issue. Like, you need to have a heater. AC, air conditioning, they don't have to have the air conditioning, except if they had it when you moved in and then it broke, then yes, that would be part of your agreement. Because if you're living in a place without a heater and you're paying $1,500 a month, that place is not worth $1,500 a month. what value would you place on you being freezing? What's the value? I mean, what is that? Is that 200 off? Is it 300 off? I don't know. We'll figure it out at trial. Okay. But there is a value. Okay, so this goes in and ties in with the fact that also, like, if you have a plumbing issue, you've asked your landlord, the toilet keeps overflowing, are you going to fix it? Landlord, next week I'll fix it, the landlord says. Next week comes, no landlord fixes it, you call again. Now, do you have the right to fix it and deduct that money from your rent? California says yes, you do. But I tell yes, you have it's called the repair and deduct remedy. But here's what I say. I tell my clients, try your best not to use that remedy. I know you have the right to do it, and the landlord should not retaliate if you do it, if you do the repair and deduct, because it's tough. Like, then the whole discussion becomes, well, you got a plumber, how much did you pay the plumber? I have a cheaper plumber, and this, that plumber is expensive, and yeah, what kind of heater did you get? You got an expensive heater, you could have gotten this at Home Depot, you know what I mean? There becomes that argument back and forth about what is the value. So what I usually tell my clients is put it in writing. And say to your client, to your client, the landlord, the value of my apartment is really not what I'm paying. I don't have a heater that works. There's a plumbing issue. It's less. I'm paying $1,500. This place is not worth $1,500. And you can say, respectfully, I may have to take this up with the authorities. Like, I may have to call the health department if you don't get this fixed, because I've been asking you to fix this for many months and you haven't done anything. You have a right to do that. In fact, I suggest if you've given the tenant, the landlord, a long time to fix something, landlord doesn't fix it, please call the health department or the housing department, because they will come in there to your apartment, they will inspect, and they'll find things that you didn't even know existed. They'll be like, oh, there's mold here. Oh, what? I didn't see any mold. They write up things like visible mold. They find things. They're like, the carbon monoxide is not, what? So they'll come in there, they'll inspect, and then they'll give a citation to the landlord. Very important. They'll give you a written citation. Here's why. Once they've inspected like that, or you've made a complaint, to your landlord to fix something, your landlord cannot increase your rent, landlord cannot decrease your services, or otherwise retaliate against you for 180 days, for 6 months. Once that inspector comes in and inspects and gives that citation, 180 days, okay? Actually, does he have to have written I don't think the inspector has to have cited. The fact that the inspector came, even if there was no citation, the fact that inspection, I don't know if you can look up. I'll look it up later. I'm not sure if the inspector has to actually cite the landlord, or the fact that the inspector is just there. I think it's once the inspector comes for 180 days, landlord cannot increase your rent. And if he does, that's retaliation. It's the presumption is that is retaliation. Okay? So isn't it nice to know all these things? It's really, people have no idea. Like, I tell some of my clients, they go, what? He's been doing this for 8 years. And I go, what? And talking about the length of time that landlords do things, there's something called the statute of limitations. How many people have heard about statute of limitations? I know you have. The statute of limitations is the amount of time you have to bring an action against somebody. Now, with landlord-tenant situation, once you move out, the day you move out is when the statute, the period starts to run. Okay, the day you move out. But it's important to know that if you have a written lease, you have 4 years to bring a lawsuit against your landlord, because a written lease is considered to be a contract. And the statute of limitations for contracts is 4 years. So you have, assuming you move out on January 29, 2019, you have up until January 29, 2023 to sue your landlord if you have a written contract. If it's an oral contract, a verbal contract, you have 2 years from the day you move out, which would be January 29, 2021. Okay? And you don't have to move out before you file an action against your landlord. I get situations where the landlord is just the worst slumlord. We have a case now, Paula's case, Paula. Her place is a slum. I don't even know how she, I just feel bad for her. She can't afford to move. You know, she's like, I'll be homeless. She has rats just like hanging out there. Like the roaches are not even scared of her. They're just, right? I mean, she has roaches all over, you know, her place. And she's not dirty. She's a clean woman who used to live in Beverly Hills. Yes, she used to live in Beverly Hills, educated, clean lady, and she's not a minority, because a lot of, you know, minorities, we tend to have that, you know, people have that preconceived thing where, yeah, it's usually the minorities who go through all of this. No, she's not a minority, right? She's a Caucasian woman who lived in Beverly Hills, had the high-profile job and the Mercedes and everything, and now she's in her situation. Really horrible. So we filed a lawsuit. When was that? December? Yeah. Put some money in her pocket because she's still living with the rodents and the roaches. Yeah, it's really sad. So I will go now really briefly to discuss rent control. Rent control is an interesting phenomenon because they have a different set of rules in every jurisdiction. Like you go to LA County, the rent control laws are different. San Francisco rent control laws are different. You know, depending on where you go, they're different. And some cities do not have rent control laws. So let me see how, I'm just going to focus on Los Angeles County. And by the way, how do you find out if your apartment is rent controlled? That's one of the resources that I said if you need, I can, you know, give you when you put your email down. But I'll just tell you, you check, it's called the RSO, the Rent Stabilization Ordinance. If you just Google RSO property search, it will come up with, you know, some page, and then you enter the property information in something called ZIMAS, under housing, and you see the RSO, and you just click, and it would just say yes or no. It would say RSO or rent sub. I don't know if it has a whole RSO or if it has a whole wording, rent stabilization ordinance, or if it's just RSO. But you click on it after you put it through ZIMAS. It's pretty easy. You just put the property address, and then you just click, and it will say yes or no. Now, if it says yes, you go hooray, because that means you're protected big time. What does that mean? Landlord cannot increase the rent by more than 3%. Landlord cannot just evict you for no reason. I mean, not paying your rent is reason for the landlord to evict you, or, you know, being completely noisy and unreasonable, you know, having loud parties, that kind of thing. But there are certain rules that apply, and you can find a lot of those rules in the RSO. And in fact, the RSO will investigate those things for you. Like if you call the rent stabilization ordinance, the agents will look into the matter, and they will tell you, well, here's what the landlord can do. If he wants you out of here, he has to pay relocation fees. You know, things of that nature. I have a case now where my client is, it was a case we tried last year, the Romo case. Oh, I have to tell you this story. So there were two men, you know, whatever. One was a veteran in his late 50s, and then the other one was probably like 30-ish. And they lived in this place in the valley where the woman, it was a woman, she converted her garage into 5 apartments. I mean, I don't know what to call it, cubicles. Yeah. They had everything, roaches, disgusting. I mean, going into the bathroom, you couldn't walk like this. You had to do like this to go to the bathroom. Yeah, it was horrible. And they were paying $550 each in the garage. They weren't allowed to cook, you know, of course, where are you going to cook in your cubicle? He says the bed was just like, I don't even know how he got a twin bed. So it was just, one of them had a twin bed, and I don't know what else he had there. I have no idea where they put their clothing. That was a place I never, did you visit? I never visited because they ended up moving out. And on top of this, on top of that disgusting setting that the woman had, she didn't even have a certificate of occupancy, which you need to have a certificate of occupancy to be renting out a place like that. It's not like she was not renting a place inside the main house. She converted the garage into 5 rooms and rented to 5 people, and they shared one bathroom, which, by the way, when you were using electricity in your cubicle and say you were blow drying your hair, the other person can iron. Okay, heater, that didn't exist. How do you get a heater with the cubicles, right? And the cubicles were not divided by walls, they were divided by cardboard. It was crazy. Yeah. We tried to settle that case. I tried so hard because my clients were just like, we'll take $5,000. I was like, okay, let me try to get you $5,000. Very, very reasonable people. I go there, whatever, shoot off an email to the lawyer. We filed a lawsuit, by the way. Oh, he complained, the clients complained to the housing department. The housing department came and said this, inspected and just said, shut this place down. This should not exist. So she did shut it down. So when they contacted me and I filed a lawsuit, and the clients were ready to take $5,000 each to settle, I was ready to take the break. I mean, I work on a contingency. I make 40%. I was ready. I'd put in hours. I mean, the first meeting was like 6 hours. They couldn't stop talking. We met like 3 times. I mean, these guys were just so mad. They couldn't stop talking. They were going on, and we were listening, remember? We were just listening to them. And so when they said 5,000, I'm like, okay, I'm thinking, there goes my shopping at Target or wherever I like shopping, TJ Maxx, there goes that purse I wanted, because I have to use the whole amount I'm making now to pay my rent, right? I'm a renter. Anyway, so I made that offer, $10,000. I'm not going to beat about the bush, because usually if you want 10, you want to say 50, and then you go haggle and go do. And I said, no, I'm just going to say 10,000. You know what his offer was? $500 each. And he's like, take it or leave it. We're not doing, and you know what? We're doing you a favor, and we're just blah, blah, blah. That was it. He was a big shot lawyer. I was just like, okay. Took it to trial. Ladies and gentlemen of the jury, I was crying. The judge was so sweet. She was like, Judge Fuji is just female. I love Judge Fuji. I hope this is not, I don't want people to see it and they'll go, well, she loves Judge Fuji, and if we get Judge Fuji, we're going to have to bump her because this woman loves Judge Fuji. But I loved her because when I wasn't like boo hoo 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 hoo, but I was just like, because and then one of my clients lost his mom, so I was just like done, like, oh. Anyway, the judge was like, oh, she was just so sweet. The bottom line is this. I gave my, statement. I explained everything. I cross-examined, and the lawyer was like, whoa, a big shot, came with his, whatever it was, PowerPoint, and like, big deal. And I had my yellow pad and my pen. That's how I try cases, yellow pad and pen. We finished, and, we decided to waive the jury, so it wasn't a jury trial. We waived the jury. And then we get the judge, took her a long time, like a month, and she gave us the finding. It was still, what did we got? It was $85,700 for both people. Judgment. So I have to go back now and get my attorney's fees. Because that doesn't include my attorney's fees. Because when you violate the civil code, and depending on what causes of action you include in the complaint, you as a lawyer, and in employment too, we're going to get to that shortly, you as a lawyer get to go back and tell the judge how much attorney's fees you're requesting. And the judge will, they'll file the opposition. The other side will say, nah, she's not even worth this. I think I was asking for, I think now I might be at $450 an hour, which is very reasonable. I've been practicing for 16 years. I work on a contingency, And she gave a tentative, actually, and I loved it. She was like, whoa, that's a very reasonable amount that Council Obiamiwe is asking for. $450 an hour for the kind of law she's practicing. I'm paraphrasing, but absolutely that's not excessive, you know. But we have to go back and argue because there's certain things that I didn't do properly and actually needed to send another lawyer because I had to be in San Bernardino for a different landlord-tenant problem. So that day I knew that, you know, my motion for attorney's fees wasn't as pressing as going to San Bernardino and trying to save somebody else. That was a different story for another day, 2.5 hours drive. But, so I get to go back in about 45 days. If you want to know what happened, how much attorney's fees I'm going to get, you can email me and I will be very happy to share. Okay? But I tell you this stories not to brag or not to slam any landlords seriously, but just to tell them that thank God we live in California. Thank God California is, you know, does the right thing to help people who are displaced or who are about to be displaced, people who are treated badly and the downtrodden and the less fortunate. Thank God we live in this state. It's a beautiful state that way. I mean, yeah, sometimes we lose cases, but for the most part, these cases will settle or they'll go to trial and we have a 50-50 chance of winning, but at least you have your day in court. Okay? And one thing I have to tell you is, again, I hope I'm not coming out like being litigious or, you know, I don't sue people who don't deserve to be sued. I don't just file frivolous lawsuits, okay? I file a lawsuit when I think that you deserve to be sued. And I have to also tell my clients that if we lose, the other side cannot come after you for attorney's fees if your lawsuit was not frivolous. If your lawsuit is frivolous, the other side can file a motion for attorney's fees. In my over 16 years of practice, I've never had there have been 2 motions for attorney's fees. One of them where I lost like 2 causes of action, and I won like 3. And so the other side was like, well, you lost 2. I'm going to go for attorney's fees on the ones that you lost. And basically what I want to say is I've never had a motion for attorney's fees granted against my client, either in employment or housing, because the only time it's granted is if the other side can show that you filed that lawsuit in bad faith, that it was frivolous. So there's a standard for that, and it's a high standard to meet because people, you know, not too many lawyers will take your case if you have no case. I'm not just going to take the case because I want to teach the landlord a lesson. I don't do that. If I don't have the evidence, I'm not going to take your case, okay? So I have to tell my clients that, you know, don't be worried because they go, well, what if I lose and they come after me? Well, I can't promise that they're not going to come after you and win, but I can tell you that it's not going to be an easy win for them because I'll fight it, okay? So going back to the rent control case that I had, here's why we got that much. We got back the money that they paid for rent, the 2.5 months of rent payment. We got all of that money back. And then there were we got punitive damages as well. So the landlord was punished for what she did, okay? And so all that money goes to my client, right? Because then I have to go and get my attorney's fees. Yeah, so going back to the rent control, oh yeah, there's a reason why. Let me tell you this. In LA County, this is very important. If the landlord does not have a certificate of occupancy in Los Angeles County, even if the property was not rent controlled, it becomes rent controlled. Did you guys know that? I love this law. I loved it. I just found out, like the beginning of last year. I called the inspector, you know, I needed him to, I subpoenaed him to appear at trial, and he told me, like, well, this is now rent controlled. I'm going, what? It's like, yes, because she doesn't have her certificate of occupancy, it becomes rent controlled. So what does that mean? She should have given them money, relocation fees. Okay? It's lovely. So with rent control, only one increase allowed every year, 3%. And here's what I just told you, here's the law. It's the Los Angeles Municipal Code Section 15105 that says, no landlord shall demand or accept rent for rental unit without first procuring and serving on the tenant or displaying in a conspicuous place a valid written registration statement. In parentheses, I call it a certificate. That again is LAMC, Los Angeles Municipal Code, Section 151.05. I have to power through this because I'm spending too much time on this. Anyway, so some form of rent regulation exists in about 17 of the 58 counties in Los Angeles. Okay, and remember, even if you put your property name in ZMAS under the RSO website and it says it's not rent control, it could still fall under the rent control, depending on what your landlord is doing, depending on whether or not your landlord has a certificate of occupancy. And why do they not have the certificate? They're trying to evade their taxes. Yeah. That's why she had, and she came in, to go back to this lady, I took her deposition and she literally skipped into the deposition, like, la, 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 and then at trial, I did a double take, like, what? She came in her little, I'm telling you, yes. She came in her little walker. They had I'm not making fun of people, but it's like, you should have seen this woman. And the problem is, I didn't record the deposition because, I'm not trying to cut costs. I didn't record that deposition where she was in a great mood and like literally walked in there without any problem. Like, and then she comes to court like, I'm going, what? I said, ma'am, are you okay? And she told her, and I was like, oh, I shouldn't have asked that answer. Oh, I have cancer. Oh, my God, you liar. You never said that when I deposed you? I didn't say that to her, but in my mind, because she's older, I have to respect her, But anyway, that's neither here nor there. But 17 counties or communities have that have the rent control. I'm going to skip all that rent control information because I believe that you can get all of that on the website. It's really self-explanatory. When you're just hanging out one day or waiting for your car to be washed or whatever, just Google that and just read it. It's just good information for you. Maybe not even for you, but to help other people. Okay. Tenants' right to withhold rent, I already talked about. And then now let's talk about the termination and eviction rules. We touched upon it a little bit with the 3-day notice, where I said that the landlord has to give you 3-day notice, not only for not paying your rent, but if you're doing anything unseemly, if you're renting your place on Airbnb and the landlord finds out, the landlord has to give you a 3-day notice, right? And then within 3 days, you have to take it off Airbnb and write a letter saying, okay, I've taken it off, and you've cured it. So technically, the landlord is supposed to forgive you. But sometimes with the Airbnb, if it's in the lease, they can just evict you. They can just serve you with a 3-day notice and just get you out of there without giving you a chance to cure. So you have to be careful about that because some people are doing the Airbnb, which I totally understand, but be careful. So there are several ways that the landlord can get you out, right? We talked about the 3-day notice to pay rent or quit or to solve whatever problem or issue the landlord alleges that you're committing or quit. So we have that. Now, then people get confused with this 30 or the 60-day notice. If you've lived in the place less than 1 year, the landlord wants you out just because, the landlord wants you out. I don't know why, but it has to be a 30-day notice if it's less than a year. But if you've lived there for more than 1 year or more, then it's a 60-day notice. And be careful. Sometimes those notices are coming right on the heels of you complaining about something. Know your rights. If that happens, call a lawyer. Okay, there's a really good a site called avvo.com. I don't know how many people know about Avvo, avvo.com. it's a whole bunch of us lawyers there. And it's not a place, it's not like lawyers are trying to really like get clients, but a bunch of lawyers who just want to do some pro bono free work. We answer questions. So you go on avo.com and you ask a question and it will tell you, there's a drop-down menu and you get to put, if it's landlord-tenant or employment, you choose whatever it is and then you post your question. It goes to all the lawyers. So it goes to all the lawyers, and we get points. Like the first 3 to respond, we get 10 points each. Yeah, so we're like, whoa. I have it on my app on my phone, so if I'm somewhere waiting on the line at Trader Joe's, sometimes I would look, is there a question on Avo? And then you get all the points, and then it looks nice when you have points. Then you get the stars after the points. It looks nice, okay? So, so it helps you, your standing and how you look in the community, but it also helps you help people. And so you put your question there, whatever area it is, the lawyers will most likely respond. And also you can sometimes click on, ask for a particular lawyer. You can look at the lawyer's name and say, I like how this lawyer, all the stars that this lawyer has, I can request this lawyer to answer. They don't have to answer, but, Wait, did I give my disclaimer at the beginning of this? I'm not your lawyer, and everything I've said today is not legal advice, okay? You have not retained me, and we have not agreed to enter into an attorney-client relationship. That was the first thing that I was supposed to say, okay? But it's not too late. It applies retroactively. Okay. So you know about the 60-day notice, the 30-day notice, when which one applies. At the end of that, then you get the eviction. That's a different story for another day with the eviction. Real quickly, you have 5 days to respond to an eviction action. Okay, and there's so many resources for evictions, so many. You go on Avo, like literally lawyers would just like answer your question, especially for eviction. And they have a whole bunch of eviction resources. I have the list here, the Disability Rights of California. We have Legal Aid Foundation of Los Angeles. They'll try that eviction case. Like they'll ask for a jury. They'll file a motion, to a demurrer motion for some kind of motion to have the judge dismiss the case. They can be really, they're advocates. They're really advocates, really amazing advocates for tenants. I love them. So I have about 11 names and that I can send to you, whoever asks, or you can take a picture of it. I'll open the page and you can take a picture before you leave. There are people out there, even in the court. There's somebody, I think they have resources to at least help you file your response, which by the way costs money, which by the way you can get a fee waiver for, okay? If you're not making, I don't know how much the money is, or if you get any kind of government assistance, like Section 8 or Medi-Cal, or you're, on disability or anything, it's waived, because I believe that the answer is about $200 and something, $225 to file an answer, and it's free. They waive it, if you meet certain criteria. One other important thing, then I move on to employment. Employment is going to go really quickly. I see this a lot, where the landlord would just go into your property with like little or no notice. Please know that in California, the landlord has to give you 24 hours. It has to be 24 hours, not less, of written notice before he can enter your unit. And he has to tell you why he's entering your unit. He can't just say, I'm going to be there on Friday at 12 o'clock. But why? Respectfully, why? Okay, he has to tell you why he's coming. The only exception is if there is an emergency. So there's a flood or there's a fire. He doesn't have to give notice for that. Okay? And sometimes they pretend there's a flood or a fire or other emergency to get in there. That's a no-no. That's actually, that would be part of your lawsuit if it gets to that. It would be an invasion of privacy, cause of action. And also, they need to give you 48 hours for the initial move-out inspection. So you're about to move out, the landlord has to also give you 48 hours to inspect the place before you move out, because sometimes they do want to inspect before you actually move out physically. Tenant protections against landlord retaliation. You know that you have a right to complain about unsafe living conditions, and you're protected. If your landlord tries to retaliate, you can do what you need to do. Consult a lawyer. There are lots of lawyers in California, thankfully, who will work your case on a contingency. What does that mean? You don't have to pay their attorney's fees until and unless they either prevail at trial, means they get a monetary judgment, or the case is settled for money. Okay, so many will work on a contingency. They might charge you a small retainer or, whatever, but it's affordable, because some of them, if you say, oh, they have a retainer, they're like, oh, you have to pay me, $1,500 retainer. If you say, I don't have it, I'll take the retainer when you settle, some of them will do that. Okay, go on avvo.com for resources. You can always shoot me an email and I'll point you out to the right direction if I can't help you. The other thing is there are special protections for victims of domestic violence. Yeah, you can quit your lease with, you know what the difference between a lease agreement and a rental agreement? Okay, a lease agreement usually is like 1 year, so you can't move out for 1 year, you're stuck. Of course, that can be broken if you have major problems, like habitability problem or the roach infestation, the big four. But victims of domestic violence can quit, just have to give 30 days notice. They're protected even in employment as well, like taking time off of work and, doing what you need to do to stay safe, to file a restraining order, whatever. Victims of domestic violence under California law, they're protected big time. So usually they'll ask you, okay, well, let me see the protective order that you got from the court. The landlord may want to see something. Like, okay, you got a protective order against, an abusive, whoever, spouse or child, and the landlord may ask you to show proof, right? Because they don't want people just making things up. So that's that. And then finally, I want to talk about the fair housing rights, protected classes, as I like to refer to them, and service animals. Fair housing rights can be under the federal or the state arm. And California Fair Housing, it's called the Fair Employment and Housing Act, actually has more protections than the federal Fair Housing Act. And it pretty much protects people on what we call a protected class. And what do I mean by protected class? Protected class means you have, you're in a category that you have no control over. So protected class could be your race, your color, your national origin, your sexual orientation, your gender, your religion, your disability, things of that such, things of that nature that you have no control over or very little control over. And then somebody's trying to target you based on that, like, oh, I don't like this Muslims. I had a case where, he was actually not a Muslim, he was a Jew. He was a Jewish guy. But the landlord thought that he was Muslim, and so he would carry his backpack, and the landlord would say, I don't know, you're gonna blow us up, Yeah, making those kinds of comments. And when he would complain and just say, this is not, I don't think it's funny, and he really was doing more than that. It's like, he would make really bad comments about Muslims, and even though he wasn't Muslim, I was able to file that lawsuit because it's the perception, okay? It's the perception that the other person has that matters. It doesn't matter that you're not that. Okay, so that's a different story for another day. That's settled too. So, so you're protected, on those bases. We call them the protected classes. Sexual harassment falls under gender. Did I say gender? Mm-hmm. Gender discrimination. Yeah, sexual harassment and, your gender identification, that all falls under the gender. I believe sometimes they use it interchangeably. I keep forgetting which one. Federal says, I think the Fed say sex and California says gender. So, yeah. So anyway, those protections like sexual harassment, gender identification, anything to do with your gender, or, whatever, you want to be called, a he or she or them, that's all protected in California. So that would be discrimination if your landlord starts treating you differently based on that. Okay? I didn't handle it, but I had a partner who handled, it was a case where the guy had AIDS, and the landlord pretty much stuck it on his wall. This guy has AIDS, put it on his apartment wall. That settled for quite a nice sum. It wasn't my case, sadly. But anyway, disabled renters' housing rights. A disabled person seeking a rental should not face questions by landlords about whether or not they have a disability or illness, and they cannot really request to see your medical records when you're applying. Okay? If you're asking for a service animal, they can ask you to show them the paperwork for the service animal. And this whole disability thing it's really huge, and it encompasses a lot of stuff. I'll give you one quick example. I had this case where my client was, again, an older woman, probably in her mid-80s, and she lived in a condominium complex. Okay? Nice condominium complex somewhere in the valley, this is ritzy and, lovely and all of that. And her son had to go every day and administer her medications to her. The son drove a truck that had a bed, one of those, I don't know what he does for a living, but he was a contractor, and he had one of those things on his truck where you carry stuff. Well, that was unsightly for this condominium complex. They didn't want that to be associated with that kind of car. Absolutely not. You could not. It was in their CC&Rs. Yes. We don't want this kind of cars in our complex. It's beneath us. Okay, so at that point I was contacted, and I said, just write a letter and just say, hey, my mom needs me to come give her medication. Once in a while I may have to spend the night there. This is my only car. And I wake up in the morning, sometimes I go to work, and they're like, we're not having any of this. They kept on giving him citations. We had to file that lawsuit. It's settled, okay? That was a disability discrimination case because the reasonable accommodation didn't even cost them 1 penny. How much does it cost for this car to be parked in front of the house? I mean, yes, it's a gorgeous place, but what's wrong? And the car was not even, the truck was a nice truck. It was white, and it had the bed, and, he would put stuff on the bed. And anyway, so reasonable accommodation can be anything. Okay, if you need an animal, you need an animal. Okay, whatever it is. If you need a fish, you need a fish. As long as your doctor can say you need this, especially in today's world, please, whatever somebody needs, can they just have it if it's not going to hurt anybody? What harm does having a fish do, or what harm does having this dog do to a landlord? Okay? The other thing is they're not really supposed to ask you for additional security deposit, but, courts will look the other way if it's not that high, because I can understand that pets make they can leave messes and stuff like that. One other really important discrimination that I've seen that's really widespread, we call it the familial status discrimination. They don't want children. Some people don't want children in their apartment. I had it this was my final year of law school. My son was a year and a half, and the landlord had a rule no children allowed to play outside. Yeah, in writing. I didn't do anything. That would have been I could have bought a nice home. Anyway, I know this is on the record, and I'm making all these comments. I'm gonna be in trouble with the state bar. Yeah, excuse me, state bar. I'm sorry, but anyway, that's a problem. That's a problem. It's a problem, first of all, to exclude people because they have children. That's also a protected class, familial status, FAMILIAL, familial status. It's a protected class. Children are children. They have no control. Now, does anybody have any questions? Because I have about 2 pages of employment law. Yes.
Can you explain about the pest control? Because you say that one of the clients get bed bugs. And
Oh, bed bugs.
yeah, and then he's been living in the place for 10 years or so.
So you would like me to explain, there's a,
Why is that? Because he said that he didn't bring the bed bugs in, but he lived there for 10 years.
yes. So are you trying to tell me, you want me to, okay, so there's a situation where a client has had bed bugs. By the way, he didn't have the bed bugs for 10 years. He lived there for 10 years, and then the bed bug problem happened. I don't know when, but we're thinking around, it was about 2 months, and then he noticed it before he complained. So where did the bed bugs come from? Sometimes you have an infestation, we don't know. I mean, they said he brought the bed bugs into the apartment, but that was just impossible. And even if he did, I mean, they still have a duty to eradicate the problem. So we never got to that level of investigating where the bed bugs came from, because other people had bed bugs in the complex. I don't know how bed bugs come. Could they come under it was a carpeted place? I don't know. It could come through underneath somewhere, and we don't know. Any other questions? No? Yeah. Well, it doesn't really matter. The landlord really needs to, except if the landlord can show, and which would be really hard, that you brought the bed bugs in, it's really the landlord's burden to take care of the bed bug infestation. What's your experience with bed bugs?
Bed bugs or roaches? Because it's under pest control.
Well, they have to spray and exterminate every so often anyway. The law says that.
Yeah, we've never had a situation where it's been proven that the tenants caused the bed bugs or the roaches infestation. But regardless, the landlord has a duty. Just as you said earlier, you have a duty to pay rent and the landlord has a duty to fix, right? So if the landlord is going to blame you for something, they have to be able to provide the evidence or the proof that you caused the problem. But a lot of times, landlords will do that. We tell you that you caused the problem because they want, either they're looking for a reason to evict you or a reason not to fix it because they don't want to spend the money. Usually, a lot of problems will be the cost of fixing the problem with the landlord, which the landlords don't like to bear.
Yes, but you're right. I'm not saying that there is no situation where a tenant did not bring the bed bugs, or, what if you're moving from one bed bug infested apartment to the next apartment? You might take the bed bugs with you and with your bed, So that's possible, but the law requires the landlords to exterminate units.
The
So-
part that gets me is that he's been there for 10 years, and there's no problem in this problem.
Clearly, somebody brought it in. Because, but that happens everywhere. I mean, bed bugs have not always existed in perpetuity. They haven't,
Hotels too.
in the hotels too. You see, it's getting widespread. I'm not sure why. And that's why I think it was July 2017, the Civil Code, where the legislature decided to actually include it. The word bed bug is actually in the statute. I believe it's Civil Code 1950 point, I don't know what it is, but it's there. Okay? But bed bugs come at some point. They were not there when the house was built, right? So at some point they come. I don't know how or what happened, but at some point they come. So yeah.
The thing here is the responsibility of the landlord.
Yes, except if the landlord can show that you brought the bed bug in. Which I'm not saying it's impossible. Maybe you do some discovery and you say, well, did you have bed bugs in your previous apartment? And the tenant says, yes. Well, and how did you get rid of it? And, I just threw some stuff in the washer, or, gives you an answer that shows that it wasn't adequately addressed. And then you could say, well, maybe you're partly negligent. And, in California, they apportion all of that. So if you're partly to blame, it's like a car accident. It's not all or nothing. It's if you're 40% to blame, you get only 60% of your damages. So that may come to play in this kind of situation. If you can show that the tenant brought the bed bugs, then the damages will be apportioned according to the blame. Or the tenant might just lose outright. Sure. Any other questions about housing? Wow, you guys know it all. Okay, I'm going to test you now. Close your books, bring out your pencils and your Scantrons. I'm just kidding. Okay, I'm going to move on to employment, because again, remember what we said, it really ties into the whole homelessness, employment laws, and knowing your rights as an employee, so that you can avoid losing your job. And if you do lose your job, you kind of know that there's help out there to help you maneuver, your situation, so that you can, get a job again, or at least go on disability until you do. Unemployment or disability until you do. So employees who are fired in violation of an employment contract. So you have an employment contract and they terminate you, or you're terminated because of your protected class, right? Remember the protected classes: race, color, gender, national origin, sexual orientation, gender, religion, disability, all of that. Remember what we talked about? So if you're being treated differently, you're being harassed, you're being discriminated, or you complain about those things, and then they start to retaliate against you, your employer, you can bring a lawsuit. Or, for instance, I have a case against McDonald's now where I have 3 plaintiffs who are African American, and they just do not promote the blacks in this. I'm not saying all McDonald's, but these are 2 restaurants. In these particular 2 restaurants, they don't promote, that's our allegation, they allegedly do not promote the blacks, right? So what does that mean? What it means is that you're not getting the money that you should be getting. It's affecting your pocketbook. The law does not like that. If you're treating people differently based on their protected class and it's affecting their pocketbook, they can file a lawsuit against you, okay, for discrimination. So the law protects workers against that. And also, if you've complained about something that your employer is doing that's illegal, like you say, well, why are you not giving me my breaks? Like, you're making me work during my lunch break. Or I clock out and you always tell me to come back. Like, I clock out, you say, oh, one more thing, go and, pick up all these things, and you're off the clock. And then you complain about that, and then they, either fire you or do something retaliatory. California protects you. So even though we have what we call an employment at will, what does that mean in California? We say California is an employment at will jurisdiction. What it means is that you can leave at any time, you can quit, give your notice, and they can fire you at any time. But they're not at will to violate the law. They're not at will to break the law. And I think at this point we need to, are we changing the tape? Oh, I thought you did this.
It's time.
Oh, it is. Aww. Okay, can I just finish in 5 minutes? Okay. So, yeah, please, this is important. So, you're being discriminated against, you're being harassed, you're being retaliated, they're demoting you, they're not sending you out on, seminars and training sessions, or they're not giving you the company car. Just look out for these things. Or they're all going out to lunch together, not getting you involved, things of that nature. Pregnancy is also another one. Pregnancy. They're treating you differently based on you being pregnant, or they think you're about to get pregnant. Most employers, and I would finish with the employment discrimination, move on to workplace injuries and workers' compensation. I like to say that workers' compensation is liability without regard to fault. So if you get injured on the job, you're just you want to, fix this TV or whatever, turn it on, and then you go up the thing and you fall down because you're clumsy, you're not really taking care of looking at where you're going, or you fall, you trip on something and you get hurt, you should be able to file your workers' comp. They're not going to say, well, you weren't looking where you're going, and therefore you have no recourse. No, workers' compensation is liability really without fault. Your employer, if you're doing anything within the scope of your employment, they really should pay, okay, for you to get treated. So it helps you recover lost wages and other accommodations. The worker must be an employee to be covered. I have a case right now. She's actually a friend she was a cleaning lady. Again, she was trying to change, I don't know what she was doing. She climbed up a ladder, maybe to change a bulb or whatever, and she couldn't file for workers' comp because she hadn't worked enough hours. You have to work X amount of hours to be able to file for workers' compensation. And I'm not going to go into that right now, but just know that there's some people who are exempt. You have to work X amount of hours. Domestic workers are exempt. They cannot file for workers' compensation. Housekeepers, nannies, babysitters usually are exempt. Agricultural workers. And then really quickly, here are some things that you can file for workers' comp for. Lung cancer resulting from secondhand smoke at a restaurant that permits smoking. Carpal tunnel syndrome caused by too many consecutive hours at the computer. A sprained ankle after falling from a telephone pole or whatever, okay? It may also include injuries from horseplay. You're just in your break room and somebody just like, boo, and then you're like, oh, and you get hurt. Employer is liable. Yes. Then we move on to denial of meal and rest break. Real quickly, you have to take your meal breaks and your rest breaks. By the way, the employer can't force you. They can't put a gun to your head and say, now go take your 30-minute break. However, they have to give you the opportunity. They can swamp you with work so that it's impossible for you to take your break. Sometimes what employers and managers will do is like they make you feel guilty. You take your 30-minute break, you didn't get your work done, and they're like, you didn't get your work done. And when you get your evaluation, it's like, oh, well, he's not really completing her work in a timely manner. Well, they're swarming you with all these tasks that are impossible to accomplish within the time that they're giving to you. Okay, that's borderline violation. Okay, so here are the penalties real quickly. You have to get, if you're working 5 hours or more, they have to give you 30 minutes. And they also have to give you 10-minute breaks every 4 hours. So if you're working an 8-hour shift, you have to get a 10-minute break in the morning, take your 30-minute lunch break, which doesn't have to be paid, does not have to be paid, but they have to give you a minimum of 30 minutes where you can just shut your eye and sleep if you want. So 10-minute in the morning, the 30-minute lunch break, some people make it 1 hour, and then the 10-minute afternoon break, which those two 10-minute breaks must be paid. You may not clock out. The employer cannot make you clock out for those breaks. It happens where they make you clock out, but they're not supposed to. If they do violate those laws, here's what the penalty is. They have to pay you 1 additional hour for the 10-minute break. But assuming they take away your 30-minute lunch and they take away your 10-minute in the morning, 10-minute at night, so they've taken 3, right? The law will only give you for 1 hour. So when I'm going back, I have this case now with 3 employees. Whew, it's going to be tough because, so we have to go back and look at, all of that information, and they basically get 1 hour a day. Going back could be 2 years, 3 years, 4 years, depending on how I plead my complaints, which I don't want to bore you with. So really quickly, the last thing I'm going to talk about is the wage and hour. Minimum wage, an employee can never waive the ability to be paid minimum wages. I don't care what you say, oh, you don't have to pay me minimum wage, fine. The burden is on the employer. That employee can still sue the employer for not paying minimum wage. Well, he put it in writing that he didn't care. I don't care. The courts don't care. You cannot waive minimum wage. Okay, and I have a thing you can take pictures of, like LA County's minimum wage and California's minimum wage. The feds are still at $7.25. Like if you go to somewhere in Alabama like that, that's how much you'd be making, I think. I haven't really looked it up, but yeah, that's the feds. So there's the minimum wage. Overtime, same thing. You can never waive your overtime. And there are laws about the overtime wages that I have. I'll be sitting here if you want me to discuss it, how it works. And I'll take questions because I'm done with employment. That was a breeze. I'll take any questions either on the record or off the record. Okay, well, it was really nice being here. Sorry if I was just like rambling on, but it was such an honor to be here, and I thank you for the time you took to be here.
We are very thankful that we had this opportunity to share this information. This is an area, both whether you're looking at where people are living or what they're doing for their living, both of these areas impact homelessness or the lack of homelessness. And I think this is a very important area to consider as we keep moving ahead with all these facets of homelessness that we'll be looking at during the rest of the week. So thank you for the insight, and we appreciate the detail and also the list of resources, and we know you're a resource.
Yes.
And you're right here.
I'm right here.
So this is really great to know that both of you are available in those ways. So thank you.
Thank you very much.